Well, thank you everybody for joining me today. My name is Emily Taylor. I'm an Arizona attorney and I practice in the Phoenix area, but I have clients throughout the state of Arizona. And today we're going to talk a little bit about estate planning basics. So whether this is a refresher for you or a brand new introduction to the topic, hopefully you'll be able to take away some information that is new to you, and we'll go through that. So with that, as an attorney, I have to say my disclaimer first, and that is just that this does not constitute an attorney-client relationship. And of course, I advocate and encourage you to find an attorney that you're comfortable working with who can represent you on your personal estate planning matters. And we'll get started. So for those of you who know me, it's good to see you and good to speak with you again. If we haven't had an opportunity to meet, I do want to share a little bit about myself and my practice. As I mentioned, my name is Emily Taylor. I'm an attorney licensed to practice in the state of Arizona. You can see here I grew up in Galena, Illinois. So Galena is a small town in northwest corner of the state, and I attended ASU, so I came to the heat 23 years ago now, and with that I've stayed in Arizona ever since. And so I feel very fortunate to call both ASU and U of A alumni, and I often joke badly that I don't have a preference in teams. I just root for whoever's winning. Since I graduated from law school in 2007, I've been practicing in the area of estate planning, special needs planning, and elder law. I am a member of the Special Needs Alliance as well as the National Academy of Elder Law Attorneys. I practice in the State Bar of Arizona and a lot of community organizations throughout the state and the community. So I'm really happy to be here, and I think we're very lucky to have a wonderful state of professionals and practitioners who work together well. And today we're going to talk a little bit about estate planning. And so with that, we'll talk generally about estate planning. We're going to break down each little area of what encompasses a general estate plan. And then we're going to go over 5 myths about estate planning, just to kind of test your knowledge. Don't worry, no scoring or grading today, but we're going to talk through some of those things. So with that, I think one of the first things we'll address is the concept of what is estate planning. The term itself has a lot of misinformation about what it is or what it isn't, but in general, estate planning is broadly the plan we have in place that is intended to control or direct what happens to ourselves, our person, as well as our assets if we're incapacitated or when we've passed away. And so with that, if you haven't been through the formal estate planning process, many of us have informal estate plans, which is the backup of guardianship, conservatorship, and probate court. We're going to talk a little bit about how today we might use a traditional written estate plan to make sure that we've got in place the right people and the right terms to take over if we're incapacitated or when we pass away. So here on the overview, you can see we're going to talk about healthcare directives, including a living will, a healthcare power of attorney, a mental health care power of attorney. We're also going to talk about last wills and trusts, as well as financial powers of attorney and beneficiaries and co-ownership. So with that, we'll start with our healthcare directives. And I often kind of find that this area gets minimized in priority or importance when people reach out to do their estate plan. They're often concerned about what happens to their money or assets. But I really believe that one of the most important things we can do while we're healthy and able to do so is put together some advanced directives and some healthcare directives that allow for the right team to be in place and the right decisions to be made on our behalf if at some time we're no longer able to advocate on our own. So with that, the term advanced directives generally encompasses a number of documents. In the state of Arizona, we have what's called a healthcare power of attorney. Most of us are probably familiar with this document. A healthcare power of attorney specifically allows us to nominate an agent, so a person or a professional, to make healthcare decisions for us when we're not able to make or communicate those healthcare decisions. Now, that might be temporarily under anesthesia, or it might be a longer term cognitive change that prohibits us from being able to make decisions. In Arizona, our healthcare power of attorney also often directs or dictates what we wish to have in place as it relates to organ donation, elective autopsy, and even our burial or cremation wishes and instructions. So a healthcare power of attorney in this instance might be a form. We're pretty lucky that our Attorney General in the state of Arizona has free healthcare directives that you can download and use, or it may be a highly personalized document. And so our goal is really to consider what are options presented in the document and make sure it's personal and unique to us. When we're making decisions about who's going to step in as our healthcare agent, we need to think about a lot of things, one of which is availability. But we mostly need to consider who can be a good advocate for us. So many of us who've been through the healthcare system recently or lately will find that there are some frustrations, and it really takes an advocate to be able to stand in for you, to understand how all of your different doctors and prescribers work together, and making sure that your wishes are in place. Now, of course, the healthcare power of attorney authority also extends outside of the hospital setting. So we do want to be mindful that our agent under a healthcare power of attorney may be making decisions about where we reside long-term if we can no longer reside at home. They may also be making end-of-life decisions. And so thinking through whether that's an individual or in some cases, perhaps a licensed fiduciary that you nominate to make those decisions for you. Occasionally, we'll have co-agents, meaning more than one person authorized to act. It's a really personal decision, and you want to spend time being mindful and intentional about how that structure is. Of course, we also want to have contingencies so that if the person or persons we've named are unwilling or unable to act, we have some backups. So really important things to think through. And frankly, the healthcare power of attorney is going to be the document we're most likely to use while we're here, and super, super important. Similarly, but different, in Arizona, we have a mental health care power of attorney. This also is available for download from our Attorney General, but a mental health care power of attorney tends to be specifically for inpatient psychiatric treatment. Of course, there are broader mental health treatments that may be appropriate, but again, we are looking to nominate an agent or agents to make decisions specific to our mental health care treatment. So it does seem a bit unique, and I'm sure if you don't have healthcare needs that are served by mental health services at this time, you may think this isn't appropriate for you, but I do encourage everyone to consider signing one of these mental health care powers of attorney if you have people you trust to make those elections for you. With both the mental health care and the healthcare power of attorney, what we're trying to prevent is from having to go to court for a guardianship. And so with this document, in the case or event of mental health services are needed, sometimes there are what we call geriatric psychiatric care facilities here in Arizona. We want to make sure that if we have individuals we trust, that those decisions stay outside of the court's purview, and we're allowed to have individuals make those decisions for us rather than requiring that emergency guardianship. Now, with the healthcare directives, we also want to give some direction about decisions that we want to be made. That tends to come up in a document called a living will. Now, it can be confusing, a last will and a living will. While many attorneys are very verbose, you think we could have come up with different terminology, but a living will is, like it says, our instruction about what happens while we're alive. But in this case, is most commonly directions as it relates to end of life and quality of life care direction. And so with that, many of us are familiar with cases like Terry Shiva, where we've had young women in very tragic accidents who are being served or kept alive on artificial life support, and then family members are disagreeing about what they would want. This is your opportunity in a living will to make some elections about what those wishes are for you based on what you know about your own personal circumstances. Now, commonly we think of irreversible comas and persistent vegetative states, but more recently, I believe these living wills, the documents have turned into a more comprehensive directive, and we do again want to make them personal to you. So oftentimes you'll see some very specific direction or instruction related to certain types of treatments or certain levels of quality of life. We also have some language in our living will that may direct certain types of care or changes in care if we have advanced Alzheimer's or dementia. So you really want to work with your attorney on making sure that your living will accurately conveys your wishes and is broad enough that as we age and we're less and less likely to be in a vegetative state, but more and more likely to have a change in our cognitive capacity or to experience one of the longer-term disease processes, that we've clearly communicated what our wishes are and what our quality of life intentions are. So super important. So those tend to be the big three of our advanced directives, but you'll recognize a few of these other acronyms down here. So we have HIPAA, which of course is a broad law that's intended to protect our privacy and our personal health information. It's very important that HIPAA is protected, but under certain circumstances, we also want to make sure that the right people can communicate with our healthcare providers and get information about our health. And so we want to craft a HIPAA waiver that allows for the right individuals to get access to our medical records when it's appropriate. You also are probably familiar with the term DNR, do not resuscitate. This is commonly a bright orange sheet of paper that very specifically outlines your intention that you're not to be resuscitated. Typically in the state of Arizona, we want your medical provider to sign off on that. And it's pretty uncommon for younger, healthier adults to have a DNR. But if it is something you want to consider, I encourage you to review the document, but also talk to your healthcare providers about that. And then most recently, we've incorporated in the state of Arizona a PULSE form, a pre-hospitalization order as to life-sustaining treatments. This again is very specific, and it is good to review with a healthcare practitioner about what your wishes are. So I encourage you to talk to your doctors if that's something you want to have in place. But generally, we're going to be looking at healthcare powers of attorney, mental health care powers of attorney, living wills, and HIPAA. I think some of the things you can do to make sure that these documents are personal and accurately reflect your wishes is to learn a little bit about processes like organ donation and long-term care decisions in terms of where you want to live. Of course, if you've been through experiences, you may already have very strong feelings, but to make these documents really effective and valuable, doesn't hurt to do a little bit of side reading to expand some of your knowledge and understanding about the healthcare directives and how they complement your estate plan are a very important part of it. So moving along, we also want to talk about financial decision making, and largely this financial decision making is focused on while you're still alive, but perhaps unable to manage your own financial affairs, or you need support and assistance in doing so. And so with the healthcare directives, we talked about this idea of guardianship, where if you don't have appropriate directives in place, the court has to get involved to take away your rights to make healthcare decisions and give them to somebody else. In the state of Arizona, that process as it relates to financial management and matters is called conservatorship. And so with that, we're trying to prevent the need for conservatorship, meaning the court has to get involved to appoint somebody to make your financial decisions when you're alive but incapacitated. And that's because the conservatorship process can be quite intense, both in time and expense, and will last for a long period of time in terms of court oversight and a number of attorneys that need to be involved. And so with that, when we're having an opportunity to put into place some estate planning documents to prevent the need of conservatorship, we want to make sure we have a financial power of attorney in place that's broad enough and encompasses all the things that may or may not come up. A lot of times these financial powers of attorney can have different titles or terms. So a lot of times you'll hear a general power of attorney or a durable financial or a property power of attorney. Regardless of what the title of the document is, we'll want to look at the document to make sure it's got the right team or lineup laid out. And similar to the similar to the healthcare, again, it can be an individual, it could be a professional, a licensed fiduciary, or a trust company, or it could be co-agents. Now, the skill set for making financial decisions is obviously very different in some cases than the skill set for healthcare decisions. So you may find that as you put your estate plan together, you have different agents on your financial documents and you do your healthcare. Sometimes there will be some overlap, but something really important to think about as we go through this. Now, informally, we also do need to be mindful of pieces that we may have put in place through financial institutions directly. So a lot of times we may have co-owners on our accounts. That's common for spouses. We may also have adult children as co-owners. We really need to understand that co-ownership does allow for and authorize assistance in making financial transactions, but it's much bigger than that in the terms that it also changes what happens when one of the owners passes away and is controlling in a lot of ways that we may not expect as it relates to liability and etc. So we don't often encourage adding individuals as co-owners solely for the purpose of having the authority to make transactions. Usually what we want to do in that case is make sure we've got a financial power of attorney in place that allows for that with the appropriate oversight and guidance, or we've specifically made sure that our financial institution has added an individual just as a signatory on an account. Each of these different options has certain benefits, certain pros and cons, and all I encourage is that as we're going through and putting together your estate plan, you're very, very mindful of how those are in place. And with that, I'll just mention that every financial institution is different, both in their paperwork, their processes, and what they do and do not allow or accept. So it is important to really make sure that you are familiar with how your accounts are structured so that what our intended estate plan through our legal documents can act in the way we want it to, and we're not relying solely on the belief that we don't have co-owners or certain signatories on accounts. Now, with the financial power of attorney, as I mentioned, we're trying to avoid conservatorship. And so even if we do have co-owners or co-signers on a lot of our accounts, there are certain financial decisions that may come up that may not be something we can add a co-owner or signer on. So that financial power of attorney is generally going to be broader. It's going to have authority as it relates to selling property, handling tax returns, making certain types of gifts. And so it's really, really important that we try to have that legal document in place as appropriate. So with that, both the healthcare powers of attorney and the financial powers of attorney really only grant authority while we're alive. And what that means is when somebody passes away, our financial power of attorney is going to stop working. However, one of the questions is when does it start working? And that's going to be unique to the paperwork that you sign. In some cases, a financial power of attorney can be effective immediately, meaning that once it's signed, the individuals you've granted that authority to have the authority to act using that. Or it can be what we would commonly call springing, meaning that the financial power of attorney really only starts to work at the time we've met certain criteria that are detailed in the document. Usually a doctor or two putting in writing that you are no longer able to manage your own financial affairs. So it's just important to really understand the documents you have and how you want that to work, because we want to make sure that we can clearly communicate to the team we've put in place or are putting in place exactly how everything's going to transpire. So if we move on to what happens then when we pass away, then there is important steps that we need to make sure we have in place. Commonly, we're familiar with the term last will and testament. This tends to be the document that we hear a lot about in movies and pop culture. A last will and testament could be that note written on a cocktail napkin before your ship sets sail across the ocean. But typically, a last will and document is going to be a last will and testament, is going to be a document that's going to do a couple important things. One is it's going to nominate a personal representative. So this term personal representative is the term that we use in Arizona in our law, and it is commonly thought of as an executor. It's going to be the individual or professional that we nominate to have the authority to step in and collect our assets, pay our bills, manage any of our taxes or final administrative procedures. They're also going to handle the distribution of our estate and make sure all of that works. A last will and testament in Arizona is also where we're going to nominate a guardian. And so if you have minor children, or if you are the guardian of an adult who's incapacitated, we're going to nominate a successor guardian in your last will and testament. A lot of times we kind of casually think of godparents or informal agreements between siblings or friends that, oh, will you take my kids if I die, that type of thing. But a guardian is really a super important nomination as well, and it's going to be important to have that in the documents in the event that applies to you, that you have minor children or an adult who you are the guardian for. And then finally, our last will and testament is going to direct our distribution of estate assets. And so even the most simple of estates and simplest wills should cover those pieces, but of course you can find last will and testaments that may be 100 pages long, a lot of one-page documents, but there are certain legal requirements that are needed to be met for the last will and testament. All of that said, there are a lot of myths or misunderstandings about how wills work. So the very first thing we need to understand is that a will is only going to control or direct assets that at our death do not have a co-owner who receives as a right of survivorship, or do not have a beneficiary designation. And so a lot of times our presumption is that our last will and testament is going to cover all of our estate and all of our assets, and that's just simply not true. We need to understand that when it comes to beneficiary designations and when it comes to co-ownerships, those contractual rights are actually going to supersede any instruction or intention that we have in our last will and testament. So if you have, oh, I don't know, a 401k that you had at your very first job, and you named your best friend as your beneficiary, you've since left that job and kind of forgot about it, and you pass away, and you now have a spouse or children or other individuals, there's the potential that there could be some real confusion and misinformation in place to control that. So a last will and testament only applies to the assets that do not have a beneficiary and are not subject to co-ownership or rights of survivorship. And in order for the person we've nominated, person or professional we've nominated as our personal representative, to actually have the power we want them to have to take on these tasks, they do have to be appointed by court. So when we hear the term probate, probate is a term that it generally encompasses an area of the court that the court supersedes a lot of these areas. So probate court has jurisdiction over guardianship and conservatorship and some of the things we talked about earlier. But it also most importantly, or most commonly thought of, is the court procedure that appoints a personal representative to administer an estate. Now in Arizona, we have a lot of different types of probate, but most commonly we have two big categories. One is intestate estate. That means the appointment of a personal representative in a case where an individual did not have a will, and there are certain rules that apply. That's your very informal estate plan if you don't have a traditional estate plan. And then we have testate probate, and that means there is a valid last will and testament, and a personal representative has been nominated. And in a testate probate, the court needs to verify the authenticity of the will and appoint the personal representative. The court then supervises that personal representative's administration of the estate, and that is commonly what we think of as the probate process. So it's a big misunderstanding that if you have a will, you don't have probate. That is not true. If you have a will and you have assets that do not have a beneficiary or non-probate transfer, you are potentially going to have to go through probate. So really important to understand that. Now, are wills still a good document to have? Absolutely, because we still get to put our wishes in place, and especially with that guardianship piece, we want to make sure that we've got the right individuals nominated. And so something to think about there. So moving on, if we start to look at trusts, with that, what we can see is that with the trust, we've got in place a similar kind of ability to nominate and put into place a lot of these different ideas. So again, there are many different types of trusts. You'll hear things like irrevocable trusts, life insurance trusts, asset protection trusts, special needs trusts, just a few for example. When we're talking about an introduction to estate planning, and most commonly the type of trust we're looking at in Arizona, we're often thinking about revocable living trusts. That means these are tools that we can change. They're revocable, and they're living, meaning they're created while we're alive. And they're trusts in the sense that they're entities where we've made elections about who's going to be in charge, trustees. We may have appointed trust protectors or other trust advisors within the documentation. These trusts are going to direct the administration of assets during our life, during our incapacity, and after death. And if properly funded, are also going to help us avoid probate. Now, with the trust, because we're putting all of these instructions into place, in order for trust to function and work the way we want to, and in order to avoid probate, we need to make sure our trust is fully funded. Now, funded means something different for everybody, and it'll depend on the nature of the assets that you have. But if you have a home, for example, we need to make sure that the title that's recorded to the home is in the name of the trust. We need to make sure that we've got our bank accounts are properly or appropriately either titled or we've got beneficiary designations. We need to really make sure that each of our assets is appropriately funded into the trust. And so it's important that if you have a trust, that you spend some time, probably annually, if not more or less frequently, making sure that if you have any new assets or if you have any assets that you may have forgotten about previously, that you've gone through the process of making sure that our ownership and our beneficiary designations are consistent. And so across the board, whether you're using beneficiary designations to avoid probate directly, whether you're hoping your last will and testament controls, understanding that it will have to go through probate, or if you have a revocable living trust, one of the most important things to do is be aware of the assets that you have and the legal structure that's set up in terms of ownership and beneficiary designation. Can't underestimate that. And so with trusts, we're going to make a lot of decisions. We're going to try to make a lot of contingencies. Our goals are to try to think of everything that may come up and to get the right team in place. But we're also planning for our beneficiaries, whether those are our minor children, our adult children, our pets. They may be charities, there may be spouses. And so the process of putting together a trust is being really, really mindful of all the different decisions you need to make, as well as the team you want to establish, so that the legal plan and estate plan you have in place can be controlling and make sure it accomplishes all the things that you were hoping to accomplish. So as I've mentioned, one of the big things that estate planning does is really thinks through and structures a plan of who is going to be your decision makers, both for healthcare and financial, who are going to be your beneficiaries, who do you want to benefit, both if you're incapacitated and when you pass away, who might be the guardian or guardians for our minor or incapacitated children, and then who are the contingencies. So if our first level of decision making or beneficiaries fails, for some reason they're unwilling or unable, or they've passed away, then who's going to be our backup plan? And so your team for estate planning is super, super important to be really mindful and contemplative of. One of the things I will mention quickly is that if you're watching this webinar, you've probably seen that we do have a workbook for estate planning in Arizona available. You can download that for free. It's just a way or a guide for you to start to think about who are some of these team members you're going to think about and putting into your estate plan, so your estate plan can be really mindful and intentional. I just encourage you to download that and start to spend some time on your own thinking through those things. It's not so much a matter of just picking the oldest child because they're the oldest child. We really want to be cognizant of the type of job or task they're going to have to take on and who's appropriate or best to do that. And so one of the other things that you'll find in the workbook is some consideration about whether or not you should consider nominating a professional and what type of professional might need to be important. So You can learn a little bit about licensed fiduciaries and trust companies in there and if they might be appropriate for your estate plan. And of course, when you're working with your estate planning attorney, it's a good idea to bring up the pros and cons of having both family members and professionals as part of your plan. So with that, I'm going to encourage you to add some beneficiaries. Oh gosh, you can tell what's on my mind. Add some questions or comments if you have any in the questions as we go through this. We're going to go through some 5 estate planning myths to kind of wrap up the introduction to estate planning. But if you have any questions or comments, go ahead and start putting those in there. So myth number 1, estate planning is only necessary when. If that were true, then it'd be a lot easier because I could just set on my calendar when everybody I know is going to need an estate plan. But the hard part is that that's not always true. So what we've learned today is that things like healthcare directives and the powers of attorney are important for everybody if you're over the age of 18. Estate planning is not only necessary when you're ready to retire, or when you're wealthy, or right before you die. Of course, if I knew when somebody was going to die, then that might be a different career path I followed. But I think the question of when I'm wealthy, it is just a misunderstanding, because with wealth, yes, of course, there are more assets to distribute, and perhaps more people might be wanting to fight over the wealth that you leave behind. But some of the most important decisions come down to decisions related to our own person and our own family, which has nothing to do with the level of wealth we've attained. And so with that, I would say everybody over age 18 should have some components of an estate plan. It may very simply be some healthcare directives and beneficiary designations when we're young adults. But as soon as we start having babies and families, it's really important to have that will with the nominated guardians. And as we do have a more complex estate and more complex beneficiaries, a trust may be a super helpful tool to make sure that the people we want to plan for have an easier path when something does happen. And so there is kind of no set time or specific life event that encourages that. And if you don't have anything in place, then I'd encourage you to at least get started with something simple. And it'll give you some comfort knowing that you've taken some steps to get the right team in place. Myth number 2, like I said, this is kind of a pop quiz, but no grading today. If I have a trust, I can't go to probate. Hopefully you heard me say it, but I can never say it too much. A lot of people have trusts that they may have done online or a long time ago, or kind of do it themselves, and they haven't properly funded trusts, and that requires them still to go to probate. So the fact that you, in and of itself, that you have a trust does not mean you are preventing probate. You need to have a trust that's funded and set up to operate correctly. So very, very important that if you have a trust or if you're updating your trust, that you are also making sure that it's remaining funded and that you don't have any assets that are going to inadvertently trigger the need for probate. Myth number 3 is I've signed my estate plan and I've funded my trust and now I'm ready to go, pun intended. I would venture to say that those are some really great first steps, but there's a few other things I would encourage. One is talking to the people you've named and nominated in your documents, whether they're individuals or professionals. It is going to be some work to step in and take some action. And so making sure that they know where these documents can be found, the team of professional advisors you have in place, whether that's attorneys or financial advisors or accountants, what kind of assets you do have. Even, when I started practicing law 15 years ago, we still a lot of times use the mail as a way to try to find out what assets people had, because people would get a lot of statements. This day and age, it's rare for people to get as many bank statements and credit card bills in the mail. And so we really need, not only do our trustees and our powers of attorney need to be able to have the legal authority, but they need to logistically know where to go and who to talk to. So there's a lot of communication. I personally believe that it's helpful to have a family or professional meeting annually to talk about things that updated and just to make sure it's open communication. It's never a fun topic to talk about these things, although I think it's very empowering and wonderful. But once you do, it really gives a sense of comfort, not only to yourself, knowing that you've communicated what your wishes and intentions are, but also to the people you're asking to step in and be involved so that they can feel more comfortable when the time comes making those decisions. So a lot of that. Myth number 4 is I have a family member who can't take care of their own finances, so I'm leaving it to their sibling or maybe their best friend or spouse or what have you. And I know or trust that they'll take care of them. And while that seems very well intentioned, unfortunately, that can lead to a lot of exposure unintentionally to that sibling or individual's own personal liabilities or their own personal estate plan. There are a lot of ways that we can plan and use special needs trust, minors trust, spendthrift trust, all sorts of different tools that we have to make sure that people who cannot, for some reason or another, manage their own finances, or perhaps just shouldn't, that we can create a structure that does provide for them in a meaningful way, but also protects those assets or resources so that who we hope to name as trustee, if they can't do it forever, we've got a backup plan and contingencies planned for. So I always encourage to be mindful in the estate planning piece that we never want to rely on another person. And, you know, as my mom used to say, or probably still does, it's not you I don't trust. It's just that things happen and other people get involved. And so we want to make sure we've got the actual proper legal structure in place so our intentions are fully followed through. And then last but not least, myth number 5 is I don't have the time or money to set up an estate plan now, but I will take care of it soon. This is kind of a joke, but also very serious. It's something that if you're watching this video, then truly you are already taking steps in the right direction. But it's never going to be the right time, or it's never going to be fun to talk about these different pieces. So anything you can do to make sure that at the very least you've got your healthcare directives in place, you've got your beneficiary designations in place. The time is now. And I really encourage you to find an attorney that you feel comfortable communicating and working with to formalize your estate plan and put it together so that we've got all of the pieces covered. Because I can tell you that it's heartbreaking to watch families go through guardianship, conservatorship, and probate processes when we could have taken steps to prevent the need from going to court in those different ways. And I think mindful estate planning can be really powerful process. And even though it is emotionally tough to kind of work through and make those decisions, it's a way to give you a sense of comfort that you've done what you can to make things as straightforward as and cared for as possible. So with that, I'll ask again if there's any questions. I haven't seen any pop up in the question and answer or the chat function. So please feel free to put those in there as we kind of wrap things up. But I hope you found this introduction to kind of some of the estate planning topics interesting and helpful. Of course, a number of these topics I can spend hours on just talking about each of them, but I will also encourage you to download that estate planning PDF workbook. It's about a 20-page PDF, and you frankly can just scroll through it and kind of read and start to journal on your own. You can print it off. Feel free to reach out to the office if you want us to mail you a copy. But its intention is to get you thinking about some of the things that you're going to need to decide to have an effective and mindful estate plan. So I hope you'll consider doing that and going through it, and I hope you find it to be a valuable tool. Like I said, I'm very involved in our community. We've got a couple events coming up I just wanted to make sure people are aware of. I am on the board of directors for the Down Syndrome Network of Arizona. We have our Back to the 80s ASU Homecoming Parade and Walk in October. We also have Yes Day for SARF, which is also at the end of October, cool event. And then Autism Life and Living is hosting a Golf for Inclusion at Shadow Mountain in November. So hopefully by then the weather here in Arizona is perfect for some golf. So I hope you'll consider joining us either for a walk, Yes Day, or the Golf for Inclusion. So I've got a couple questions here, I think. So one of the questions is, do we need to redo our will and directives if we move? So that is a question that gets asked a lot. Of course, people move from state to state. So the general answer is a lot of the documents, if you've prepared them in the United States, they should work in a new state. That being said, each state does have slightly different rules. And so I always encourage individuals, whether moving to or from Arizona, to meet with an attorney and review their current estate plan with an attorney in that state to really understand. So for example, in Arizona, like I mentioned, that mental health care power of attorney is pretty unique. A lot of people moving to Arizona may not have that mental health authority in there. Also, financially, one of the big changes from state to state is some states have an estate tax. So there's a federal estate tax, but in addition, there are some states that have a state estate tax. We do not in Arizona. So that's good, but sometimes the format or function of an estate plan done in another state that does may not be appropriate. I also just encourage everybody to review their estate plan every couple of years with their attorney. So if, for example, it's been 5-10 years since you put together your estate plan, not a bad idea to just set up a time to chat with your attorney to review it. There's changes in technology and laws, as well as changes in your family dynamics. So either way, yes, if you're moving to or from Arizona, I encourage you to have an attorney review your estate plan and make sure it's effective and it covers all of the elements that need to be covered in the new state. I know it's not a process we want to do more than once, but if you're lucky to, I hope you get a chance to do more than one estate plan, because that means you've been prepared and and had a good plan in place. And I think that works really well. So hopefully that answered that question. I'll wait and see if any more pop up, but with that, I'll also encourage you to please feel free and comfortable to reach out to my office if we can help in any way. Like I mentioned, I'm licensed to practice in the state of Arizona, so I have clients throughout the state. Basically, happy to chat with you, and if you need an attorney in another state, we have some resources to find some good practitioners there. Most importantly, I just hope that you find an attorney that is somebody that you feel comfortable talking to and that you feel like is doing a good job of explaining how this all works, because the last thing we want to do is have a hefty, expensive estate plan in place that you don't understand. So I'll encourage you to keep looking until you find somebody that really can make sure you feel comfortable with the plan you have in place and takes the energy and time to help you work through who those different decision makers are. I don't see any other questions popping up. So if something does come up and you want to reach out, please feel free to email or call. You can schedule consultations through our website or send us an email. All of our contact information is there. And of course, our phone number is listed there as well. I will thank you for your time today and hope that you have a wonderful estate planning process. And I'm so glad you've gotten started by watching this video, and thank you for your time.